Thank you, Paul, for a fine presentation. Same to Kevin Porter and Jennifer Short. We have a couple of minutes. I'm going to ask one question and get all three of you to weigh in if you'd like. And we'll start with the first presenter, and that would have been Jennifer. So this is the question. What can I or my company do to avoid a whistleblower suit?
I love this question. So I'm going to give my somewhat snarky answer. But this is true. You cannot do anything to stop somebody who wants to sue you under this act from actually filing a case. But there are a couple of things that companies can do to reduce the risk that they are going to be subject to a whistleblower lawsuit. I would say, just as a practical matter, not as a legal matter, but as a practical matter, if you have the type of compliance program or a reporting mechanism or company environment, an atmosphere that allows employees to come forward and make complaints and feel like they are being heard and their complaints are being taken seriously, companies can really reduce the number of people who feel like the company has done something wrong and isn't willing to fix it. Those are, actually the whistleblowers who go forward and try to file a lawsuit. They've typically had a bad employment experience. Not all the time. There are whistleblowers that come. It can be a competitor. It can be, some of the bigger cases these days are being brought by companies that do data mining, and they can look through Medicare and Medicaid claims, or they can look through contract data and try to pinpoint companies that have potential False Claims Act issues. But in terms of the traditional whistleblower action, I think one of the things that companies can really do is to put those compliance procedures in place, the ones that Kevin talked about, applicable to whatever industry you're in, and be able to be on the lookout for those dissatisfied employees who are raising issues. So that's my number one piece of advice. You can't stop from being sued, but you can try to make your employees happy.
Okay, Jennifer, thank you for that. Kevin and Paul, we want to give you each a minute because we are running out of time here about the whistleblower suit avoidance. Let's start with Kevin.
Okay, thank you. I agree with what Jen said. I thought those were very good points. I would just add to that. I think it's good to have in a compliance program. If you have a good compliance program where the employees know about it, feel that it's real, feel that it's really trying to work with the staff, I think that's a big component of avoiding a relator complaint. And I think a key element sometimes is having an anonymous method to file a complaint, so that if a complaint is in New York, but in many states, you can make a call to a telephone number, not reveal who you are, and bring up the issue. And what a lot of smart facilities will do, the issue may involve a certain department, a certain clinical area. They'll look into it, do a confidential inquiry, and if they find something that is maybe a little bit amiss, they might implement a policy change so that employees in that particular area know that an action has been taken as a consequence of it. And if someone comes forward directly to the healthcare compliance officer, who in a lot of places reports directly to the chief executive officer and to the board, and the employee raises the issue, and you get back to that employee in a very realistic way, explain your findings and indicate what steps are going to be taken to tighten things up. I think a lot of it has to do with basic communication, and the communication has to be effective.
Thank you, Kevin. Paul Chan, we want to give you a minute to weigh in on avoiding those whistleblower lawsuits.
Sure. I'd echo what Jennifer and Kevin said. It's very difficult to avoid the lawsuits altogether. but companies can take steps to really minimize or perhaps persuade the government not to move forward with these actions even after they've been reported. And so in addition to focusing on the compliance efforts beforehand, I would really counsel clients and companies to spend time really working during the investigative phase of the action before the government decides whether it will intervene or not, often before the complaint has even been unsealed. The way to think about these cases is that they're almost two-part cases in that the biggest and one of the most time-consuming fights is about whether the government will decide to intervene or not. And then second is litigating the case after it's made the intervention decision. So I would counsel companies to really focus on not just compliance, but really trying to make a good faith showing to the government that the violations either did not happen or are not severe, and that the government should not intervene, because that's a crucial stage of the process, even before you get to litigation.